David Bernstein is an attorney who's been in practice for over 12 years. His practice focuses on estate and tax planning, concentrating on the preparation of living trust arrangements. David Bernstein has appeared on the Morning Exchange and has been interviewed by the Plain Dealer. He can be heard weekdays at 2:30 p.m. on radio station WRMR AM 850 for his daily estate planning tip. He also has a monthly newspaper column on estate planning in senior lifestyles. Today, David Bernstein will talk to you about living trust arrangements.
Hello. Today we're going to talk about living trust arrangements. There are three main reasons that we set up a living trust. The first main reason is to avoid probate. Now, what's wrong with probate? Well, first of all, probate is totally public. Imagine doing this. On a blank sheet of paper, list all of your assets, every asset that you own, your financial assets, your real estate assets, every asset that you own. Give a detailed description of each and every asset. For financial assets, give financial information, and for every single asset that you own, give a to-the-penny dollar value of each and every asset. On a second sheet of paper, list all of your liabilities, who your creditors are, what the purpose of each debt is, and a to-the-penny dollar value of each and every debt. On a third sheet of paper, list your beneficiaries and how your estate will be distributed to them after you pass away. Take this information down to the probate court. Walk up to the probate clerk at the probate desk and hand these sheets to the probate clerk and instruct the probate clerk that you want him to post it on the bulletin board in the hallway, because you want the whole world to know exactly what's going on in your estate right now while you're alive. Well, no one I know would do that while they're alive. But everything that I've described to you happens with probate. All of that information becomes a matter of public record. And anyone in the world who wants to can go down and look that information up. Anyone includes unscrupulous solicitors, unscrupulous creditors, nosy neighbors, nosy relatives. All the people that you typically would not want to know what's going on in your estate, unfortunately, are the types of people that bother to go down and look that information up. Now, with a living trust arrangement, on the other hand, your estate remains totally private. The only people that know what's going on in your estate are the people that you specifically want to know. No one else gets a peek at any of that information. So a living trust is totally private. The second problem with probate is very expensive. Probate typically costs between 5 to 10% of the gross value, not the net value, but the gross value of your estate. And that's 5 to 10% that will go to the probate attorneys and the probate system, but not to your children, your grandchildren, your beneficiaries, the people that you really care about. Most people have simple wills. And what they don't realize with a simple will is that a simple will guarantee, that's right, it will guarantee that your estate will go through probate. It doesn't avoid probate, it guarantees probate. And most people don't realize that with their simple will, they have a phrase, they have a provision in their will that reads something like this. And to my beloved probate attorney, I leave 10% of my estate. Well, you won't see that written in your will, but by the operation of probate, that's exactly what happens. And I don't really know anyone who refers to their probate attorney as being a beloved heir of their estate. But that's what happens when you have probate. Now, with a living trust arrangement, on the other hand, I charge a one-time fixed fee of $250. And that will take care of preparing all the documents that we'll be going over today in your living trust arrangement, as well as changes to your trust, which are called amendments. And we'll talk about the procedure for changes at the very end of this session. Now, the third problem with probate is probate takes a long time. Probate typically takes between 1 and 3 years, on average over 18 months. During that time, your estate is frozen in the probate system, and nothing can be done without the express written permission of the probate court and the executor of your estate. And that's a long time for your estate to be locked up in a system of artificial delays, that is, the probate system. Now, with a living trust arrangement, on the other hand, your estate can be settled in as little as 4 to 6 weeks. It may take a little longer than 4 to 6 weeks. It may take less time than 4 to 6 weeks. But that's based upon normal business transactions, not the system of artificial delays that the probate system imposes on your estate. So a living trust also is much faster than probate. The second main reason that we set up a living trust arrangement is to avoid a guardianship. If you should become incapacitated and you can no longer take care of your financial or legal affairs, someone else, if you're married, typically your competent spouse, if you're not married, a close friend or relative, would have to go down to the probate court. That's right, the probate court, and have themselves or someone else appointed as your legal guardian. Now, the probate court typically will appoint your competent spouse or the friend or relative who applies for the guardianship for you as your guardian. But they don't have to. They can appoint anyone they choose. In addition to appointing a guardian, the probate court will typically appoint an attorney to represent the guardianship, to take care of all the complex legal filings that go on while the guardianship is in effect. And because of this, a guardianship can cost up to and over $20,000 per year while it's in effect. Now, while it's in effect is a very important concept, because if you later regain your competence, you don't simply walk into the probate judge's office one day and say, "Hey, Your Honor, I'm okay now. I'm going to take over again." No, instead, you must petition the probate court to prove your competence. And just because you believe you're competent does not mean the probate judge has to agree. The probate judge can leave the guardianship in effect indefinitely. Also, let's not forget about the attorney who represents the guardianship. That attorney has a built-in conflict of interest. He will only be paid so long as the guardianship remains in effect. So often what he will do while this is going on is petition the probate court to keep the guardianship in effect. He'll tell you that it's in your own best interest. The reality is it will be in his best financial interests. So now you may have to hire a second attorney to represent you to get rid of the guardianship. So now you'll have two attorneys working for you, one to keep the guardianship in effect, the other to get rid of the guardianship. Both attorneys will be paid for out of the assets and the value of your estate. Probate, guardianships, neither of them will make your estate bigger, they both make it smaller. And with both probate and a guardianship, you lose control over your estate. And with a guardianship, you lose control over your financial and legal affairs as well. Now, with a living trust arrangement, we totally avoid the need for a guardianship. You and you alone determine who will back you up if you should become incapacitated. And if you later regain your capacity, you automatically take over again. You don't have to beg a probate judge, "Well, gee, Your Honor, could I just start paying a few of my bills to prove that I'm competent?" No, instead, it's automatic. So with a living trust arrangement, we totally avoid a guardianship. The third main reason that we set up a living trust arrangement is to avoid paying federal estate taxes. Now, you do not avoid any Ohio estate taxes either with your will or with a trust, but there's a big difference between federal estate taxes and Ohio estate taxes. Ohio estate taxes start at 2%. They cap out at 7%. The money stays here in Ohio and is used primarily for educational purposes. Federal estate taxes, on the other hand, start at 37% for estates over $600,000 in value. They cap out at 60%. None of that money stays here in Ohio, but instead all of it goes to Washington, D.C. to be spent on all of the programs there, but not on your children, your grandchildren, the people that you care about. Most people have simple wills, as I mentioned before, and what they don't realize is simple wills are terrible methods of estate planning to protect your estate from taxes. It would be like having a provision in your will that reads like this: "And to the beloved Internal Revenue Service, I leave 37 to 60% of my estate over $600,000 in value." Well, frankly, I have never seen a will that says the beloved Internal Revenue Service, and you'll probably never even see in print the words beloved Internal Revenue Service. But that's the operation of a simple will. It's terrible for estate planning. Now, a living trust, with a living trust, you certainly do avoid those taxes. But all of that planning that you can do with a trust, you certainly could do with a will alone. However, you're back in probate, and you're still subject to a guardianship. So a living trust allows you to take full advantage over all of the good tax planning that's otherwise available to you. Many people ask me, how long have living trusts been around? Are they something new? And the answer is no. Living trusts have been in existence for over 800 years. They started out in Europe, and when this country was established, they came over and became part of our laws. And then people will ask me, well, if living trusts have been around so long, Why hasn't my attorney told me about setting up a living trust? And the answer is, most attorneys engage in general practice, and that means that a large part of their practice involves probate. They're not going to tell you about something that eliminates part of their practice, that is probate. So they don't feel comfortable telling you, well, here's how to eliminate probate, and therefore I won't get as much of the fees as I would have otherwise have gotten. And then people will ask me, how large does my estate need to be in order to have a living trust? And the answer is your estate doesn't have to be very large in order to benefit from a living trust. Typically, an estate of $50,000 or more will benefit from a living trust arrangement. Why? Because we eliminate those probate fees, that 5 to 10% of your estate. So if you figure it out, a $50,000 estate could cost your beneficiaries between $2,500 and $5,000 in probate fees based on the normal fee structure. And that's a very large part of a relatively small estate, and that has an even greater impact on your beneficiaries. So even a small estate will benefit from a living trust arrangement. It doesn't have to be large. Living trusts are not exclusively for the very wealthy. They're for the everyday, ordinary people. Many people will also ask me, well, doesn't joint ownership avoid probate? And the answer is not necessarily. You see, if you're married and you have joint ownership of your assets with your spouse, you're merely going to postpone probate. When the first spouse dies, everything will pass through joint ownership to the surviving spouse without any probate. However, when the surviving spouse dies, then all of your estate will have to go through probate. As you can see, joint ownership merely postpones probate. And then I'll be asked, well, what if I were, as a single person, to put my assets in joint ownership with my children to avoid probate? And the answer again is, well, yes, that will avoid probate, but let's look at some of the problems involved here. When you set up joint ownership with your children, you become partners with your children. You become partners with your children in all the things that can go wrong. If they have a divorce, that property in the joint ownership could be subject to a claim as part of the property settlement. And that's certainly not what you had in mind when you set up a joint ownership with your children. If your child becomes involved in an automobile accident or some other type of lawsuit, his creditors are going to go over that asset as well in order to satisfy that claim. So again, you have a problem. If your child becomes involved in tax problems or other types of problems, for example, your jointly owned property could be subject to the influence of your children's spouses. Additionally, joint ownership creates poor tax consequences for your beneficiaries. Another problem with joint ownership is joint ownership can result in unintentional disinheritance of loved ones, of your family, your beneficiaries. Let's talk about the effects of what happens with joint ownership with second marriages, for example. Here we see Bob and Sue. Bob and Sue are on their second marriage. Bob, as a loving husband, has gifted his house in joint ownership to his wife, so they now own it together. When Bob dies, Sue, as a joint owner, will inherit that house. When Sue dies, that house will go to Sue's family. So as you can see, Bob's family, on the other hand, got nothing. Well, that was joint ownership, and it certainly avoided probate, but it also caused the entire estate to be lost as well. And that's not a good situation either. Another problem with joint ownership is it receives very poor tax treatment. Jointly owned assets do not receive stepped-up basis for capital gains tax purposes. Gifts that pass as a result of a will, or better yet, as a result of your living trust, that is, gifts that pass at your death, do receive that favorable tax treatment, that is, stepped-up basis for capital gains tax purposes. And that means that instead of your beneficiaries having to pay heavy capital gains taxes because they own that asset with you jointly, and then after they sell it, those taxes will be due, instead, none of those taxes are payable because of the stepped-up basis. That is, the more favorable tax treatment that your estate will receive as a gift of death, an asset that passes after you pass away. So as you can see, joint ownership is not the solution to avoiding probate. So what instead is the solution? The solution is to set up a living trust arrangement. A living trust arrangement is very easy, very simple to set up. Now we're going to talk about who is involved in your living trust. This is what we call your living trust team. First of all, you, or if you're married, you and your spouse are the creators of the trust. That is called the trustors. You're also the first set of managers of the trust, and that is called the trustees. As creators and managers of the trust, you can buy, sell, give things away, move assets into the trust or out of the trust at any time, change or even revoke the trust. You will not need anyone's permission to do any of these things. You'll just do your normal business transactions. You'll be filing your tax returns exactly the way you've done in the past. You don't need a new tax identification number. You don't need a new tax return to fill out. The government has no procedure or requirement for you to register or file your trust anywhere, so your trust remains totally private to you. Now, if you're married and if you die, resign, or become incapacitated, your spouse will take over as the sole trustee. And if you're single or if you're married and after both of you pass away, your first backup trustee will take over if you die, resign, or become incapacitated. Now, your backup trustee can be anyone you want. Children, other relatives, friends, a corporate trustee such as a bank. Anyone you want can be your backup trustee. And that includes people that even live out of state or out of the country. There's no requirement that they be residents of Ohio to be your backup trustee. After your backup trustee are your beneficiaries. And again, your beneficiaries can be anyone you want. Children, grandchildren, other relatives, friends, charitable institutions. Anyone you want can be your beneficiaries. And your beneficiaries can also be your backup trustees as well. There's no limitation. There's no prohibition on that whatsoever. So you can choose anyone you want. If you have minor children, you will need, and included in your trust will be, a children's trust and a children's trustee to take care of their inheritance while they're under the age of distribution. Also, we will need to appoint a guardian for those minor children. Guardianships for minor children take place in the probate court as well. So we'll have to appoint a guardian for any minor children that you may have if that situation applies. Then, of course, there are your children. Your children, as I mentioned, can be both your beneficiaries as well as your backup trustees. There's no limitation. There's no prohibition on that whatsoever. You can choose anyone you want to take the roles that we've just gone through. Now let's discuss the documents that will be found in your living trust. The first document found in your living trust is the abstract of trust. The abstract of trust is a signed, notarized, summarized version of your trust. It provides proof of your trust. Some banks, some financial institutions will say when you go to transfer your financial assets from you to you in trust that they need to see proof of your trust. Well, rather than give them a complete copy of your living trust, which, by the way, contains your entire private estate plan. And by the way, also, bank employees are strangers too. They're not members of your family. Why should they get a copy of your estate plan and know information that's typically private or confidential? Instead, you will give them a copy, and I'll emphasize this, a copy only. Do not give anyone originals of any of your documents. You can give them a copy of the abstract of trust. The abstract of trust is a summarized version of your trust with only generic language, nothing private or confidential that you wouldn't want strangers, that is, bank employees, to know about your estate. The next document in your living trust arrangement is the trust itself. The trust itself is very similar in many ways to a will, except, of course, it avoids probate and avoids a guardianship, and it also minimizes or eliminates your federal estate taxes. The living trust contains your instructions, and these instructions include such things as who will back you up if you should become incapacitated or after you pass away, what specific gifts of property will be given and to whom they will be given to, the remainder of your estate and how it will be divided up, what percentage shares. If one of your beneficiaries should die with you in a common accident or die before you and you don't have a chance to amend your trust to reflect this change, we can also include a provision to allow you to ensure that their children will step forward and represent their parents and take their parents' share as if the parents were still alive. That is called right of representation. Right of representation follows the principle of family bloodlines only. It doesn't go, for example, to your children's spouses instead, because we know what can happen with those situations. Your children's spouses can remarry, and then if they pass away, their spouse takes over that share of the estate. And then when that person passes away, that share goes to their family. Well, the people that I've just mentioned are total strangers to you and your family. They're people that you've never even met, and yet somehow they could receive a share of your estate without proper planning. Instead, we use family bloodlines only, so we ensure that it stays within your family bloodlines. That is how your estate is passed on. Also, for those beneficiaries, if they're minors, we'll be including an age of distribution provision. An age of distribution provision allows you to ensure that they will not get their share of an estate at too young an age. I'll go through an example with you. Let's say, based on circumstances, that your grandson will now inherit your estate. Let's go through an example of what can happen without proper planning. Let's say, based upon circumstances, that one of your heirs will be your grandchild, who will step forward and take his parent's share. What can happen? Well, under Ohio and other state laws, a minor beneficiary, upon reaching the age of 18 or 21, depending on the state law involved, and depending on the nature of the asset involved, will take their full share of the inheritance as young as age 18 or age 21. Well, what can that mean? Well, let's say your grandson, at age 18, will inherit $100,000 in cash that he can spend any way he wants. Now, what's an 18-year-old going to do with $100,000 in cash that he can spend any way he wants? Well, let me share with you what I would have done when I was 18. This was my thinking at the time. The first thing I would have done would be to buy a car. Now, it wasn't just going to be any car. It was going to be a Corvette, a red convertible Corvette, with every option that the dealer could provide and every option that I could get customized on that car. Today, that car would cost only around $70,000. Well, that's all right, though, because I'm 18 years old, and I still have $30,000 of cash left to spend. And I guarantee you, when I was 18, that $30,000 of cash would have lasted me at least 3, perhaps even 4 months before it was all spent. In addition to spending that money on things that were foolish, I might have spent that money on things that weren't good for me, things that could have destroyed my life. I would have been better off not getting a single penny instead of getting any of that money. Now, what we can do with your living trust arrangement is raise that age of distribution to a much more responsible and reasonable age. I recommend a starting age of distribution to my clients of age 25. Why do I recommend 25? Well, what we find is that the first signs of intelligent life begin to appear around age 25. Now, I said the first signs of intelligent life. I didn't say anything about being intelligent or mature yet. If you drop $100,000 of cash in the lap of a 25-year-old, they may still go buy that car, or they may still do foolish or self-destructive things with that money. So what we do instead is we have a starting age of distribution of 25 and then sprinkle it over a longer period. For example, starting at age 25, 10% a year over 10 years, or 5% a year over 20 years, or whatever distribution pattern that you decide upon. And you can even later customize, that is, tailor that provision to specific contingent beneficiaries based upon your observations of them over time. Some may need more time, some may need less time. So you always have the flexibility to adapt your trust based upon the circumstances involved with very simple amendments. Also included in your living trust will be proper tax planning. Remember, I told you before that a simple will is very poor in its tax planning. Simple wills typically ensure that the maximum amount of taxes will be paid by your estate. Now, with a living trust arrangement, we can do some very simple tax planning. If you're married, we can set up what's called an A-B trust if your estate is over $600,000 in value. Let's first talk about what happens with the poor tax planning of a simple will. Most people have simple wills. And with their simple wills, everything goes to the surviving spouse. And that means when the first spouse passes away, everything will go to the surviving spouse without any taxes being due at that time. That's using what's called the unlimited marital deduction. However, every person gets a $600,000 exemption. Now, if you use the unlimited marital deduction with a simple will, you're going to throw away the first $600,000 exemption. And that means that when the surviving spouse dies, the full amount of the estate will be subject to the taxes. And since we only have one remaining $600,000 exemption, we now have the full estate minus the one remaining $600,000 exemption, resulting in the full taxation. An example would be, let's say you have an estate of, for example, $900,000 in value. When the first spouse dies, everything goes to the surviving spouse without any of those taxes. However, when the surviving spouse dies, as I mentioned, we only have one remaining $600,000 exemption. So now we have a gross estate of $900,000 minus the one remaining $600,000 exemption, resulting in a taxable estate of $300,000. Now, if you recall, I told you that taxes start for estates at 37% and they cap out at 60%. We use, for illustration purposes, an average rate of 40% here. We have a taxable estate of $300,000. Taxed at 40% results in a tax due of $120,000 due to the IRS within 9 months after the death of the surviving spouse. Now, it's due to the IRS in 9 months, and it's due in cash. The IRS is not interested in having anything but cash, and that means that your estate, part of your estate, may have to be sold at less than fair market value to raise that cash. Now, the IRS will allow you to postpone paying those taxes, but then you have to pay interest. And that means that your estate taxes actually continue to go up because the interest continues to go up. Now, with a living trust arrangement, we can do very simple tax planning, and this is called an A-B trust. First, we start out with your estate at a common estate. Now, in this illustration, you see we have a $1.2 million estate. And the reason that we show in this illustration a $1.2 million estate is because that is both $600,000 exemptions added together. That is the maximum that we can avoid paying any federal estate taxes on with very, very simple tax planning. Now, when the first spouse dies, the trust will automatically split into two separate trusts. The A trust is for the surviving spouse, and the B trust is for the deceased spouse. Now, I'm going to give you a way to remember this that you'll probably never forget. I apologize in advance. It's a little morbid, but it's a very excellent way of remembering it. The A trust is for the surviving spouse. The B trust is for the deceased spouse. A is for above ground. B is for below ground. Well, I'm sorry. I apologize. I admit it is a little morbid, but you'll probably never forget it now. A above, B below. Now, as I mentioned, the A trust is for the surviving spouse. The surviving spouse will have full power and control over all of the principal assets in the A trust, and that means that he or she can start spending the assets in the trust any way he or she pleases. Now, typically, they're not going to do that because you don't know how much money you're going to need to live on for the rest of your life. So instead, what you would typically do is invest that money and then live off the income. Now, in this example, we're going to assume that the rate of return is 10%. It's an easy number to work with, and it also helps us illustrate the point. Well, the surviving spouse, in addition to having all the principal to use of the A trust, also gets all of the income of the A trust as well. And in this example, that would be $60,000 per year for the surviving spouse to live on. Additionally, the surviving spouse gets all of the income of the B trust as well each year to live on. And in this example, that would be another $60,000. Also, the surviving spouse gets the greater of 5% or $5,000 of the principal value of the B trust each year to live on as well. And in this example, that would be $600,000 at 5%, resulting in $30,000 additional each year for the surviving spouse to live on. So let's add all this together and see what we have. That means that the surviving spouse gets $60,000 a year of income from the A trust, $60,000 a year of income from the B trust, and $30,000 a year of principal from the B trust as well in this example to live on. That adds up to $150,000 per year for the surviving spouse to live on each year in this example. But what if $150,000 is not sufficient for the surviving spouse to live on? And you're probably thinking, well, My goodness, that's a lot of money. Most people would have no trouble living on $150,000 per year. However, what if there's a catastrophic illness? What if interest rates go down? Well, the surviving spouse, in addition to having all the income of the A trust and all the income of the B trust, and a small amount each year of the principal of the B trust, and all the principal of the A trust, will additionally get to take all of the principal of the B trust as well, to take care of his or her health, education, or standard of living expenses. Now, healthcare expenses are easy to determine. They're based upon medical bills. Education expenses are based upon tuition bills. Standard of living expenses are based upon the standard of living of both spouses at the time of the death of the first spouse. So the surviving spouse will have full power and full control over all the income of both trusts and all the principal of both trusts when it's needed. When the surviving spouse passes away, then the two trusts merge into a single trust, and your entire estate will pass to your beneficiaries without any probate fees, which in this example would have been about $50,000 to $100,000, and without any federal estate taxes, which in this example would have amounted to $235,000. And by the way, that's over $300,000 that instead of going to your beneficiaries would have gone to the IRS and to the probate system, the probate attorneys. And most people don't think of them as heirs, but as I mentioned, simple wills are very poor methods of planning. Now, as a matter of good financial and tax planning, you'll want to put the slower growing assets into the A trust and the faster growing assets into the B trust. The surviving spouse has 6 months after the death of the first spouse to make this allocation. However, what I recommend to my clients is don't wait for the surviving spouse to be left alone to make these decisions. Instead, while you're both alive, sit down together and as a minimum on a yearly basis, figure out on paper, here's what we would put into the A trust, here's what we would put into the B trust. This way, your spouse is not left with questions rather than answers. This way, instead, your spouse has a plan to follow to figure out how to make that allocation. Now, the reason that we put the faster growing assets into the B trust is these assets are frozen for federal estate tax purposes. Let's assume in this example that there's a 20-year period between the death of the first spouse and the death of the surviving spouse. And during that 20-year period, those assets grow in value to be worth $1 million in value. And by the way, if they've grown to be worth $1 million over a 20-year period, they have not even kept up with inflation. But I use $1 million as a figure to illustrate the point because it's a conservative number and it's an easy number to work with. Well, we now have an additional $400,000 of estate that taxed under the simple method, that is, the simple will method, would have resulted in additional taxes of $160,000. Now, with very simple tax planning using the AB trust, we avoid those additional taxes on your estate based on appreciation. Those assets will not be retaxed when the surviving spouse dies. So therefore, we would eliminate, in this example, $160,000 of federal estate taxes. Another thing to consider is gifts during life, as I mentioned before, do not receive stepped-up basis for capital gains tax purposes. Gifts at death do. So that means that if these assets are sold after the surviving spouse dies by the beneficiary, they will not result in additional capital gains taxes that otherwise would have to be paid if they're sold as a gift of life. And that means we have an additional $400,000 of capital gain, which taxed at the normal capital gain rate of, it's typically 15 or 28%. Let's use 28% in this example, would result in an additional over $100,000 of capital gains taxes that would have had to be paid. However, because these assets are stepped up in basis, that tax is totally avoided as well. So let's review now. We saved the original probate fees of $50,000 to $100,000. We saved the original federal estate taxes of $235,000. We saved the federal estate taxes on appreciation of $160,000. And we also saved the capital gains taxes on appreciation of $112,000. That is over $600,000, over half of the original estate. It is not unusual for the Internal Revenue Service to be the largest single heir of an estate. And with a simple will, that's exactly what it would have happened. However, with the planning that's just been illustrated, all of that money instead goes to your beneficiaries, the people you care about, instead of to the probate attorneys and the Internal Revenue Service. The Internal Revenue Service actually needs this money more than your beneficiaries do. Remember, they have a huge debt to pay off. The thing is to keep in mind is they don't deserve it more than your beneficiaries. So with this planning, we eliminate the probate fees, we eliminate the taxes. Now, if you're married and your estate is over $1.2 million in value, or if you're single and your estate is over $600,000 in value, we can include other tax planning, again included in the original fee, the total fixed fee, at no additional charge, other types of tax planning to eliminate or avoid federal estate taxes in those instances. One of the methods involves an irrevocable trust that's typically funded with life insurance. Now, to go through the entire process of explaining an irrevocable trust with life insurance is beyond the scope of the time that we have available to today. But let me just emphasize to you, this is very simple tax planning as well, which allows you to eliminate those federal estate taxes. Also, if you have retirement plans, we can minimize the income taxes that otherwise would be due with very simple tax planning in your living trust arrangement to minimize those income taxes. And again, this is beyond the scope of our discussion today, but let me again emphasize it's also very simple tax planning, which is again included as part of the original fee, no additional charge, in order to set these arrangements up for you. Now, the next document in your living trust arrangement is your durable power of attorney for financial and legal affairs. This is the document that allows you to ensure that there will not be a guardianship if you should become incapacitated. It covers what I call go-forward transactions. Go-forward transactions are powers that you cannot put into a trust, but instead can put into a durable power of attorney for financial and legal affairs. Go-forward transactions cover such things as taking care of filing your tax returns, filing Social Security benefits, Medicare, insurance, pension benefits. These are powers that you cannot put into your trust, but instead can put into a durable power of attorney for financial and legal affairs. Also, let's say that period of incapacity is a long period of incapacity. And because of this, changes need to be made to your estate plan. Well, if you're married and you're incapacitated and changes need to be made, could your competent spouse sign your new will for you? And the answer, of course, is no. Only you can sign your will, but in this example, not even you can sign your will because you're incapacitated. So now your estate plan has frozen. It's locked up. And you lack the flexibility that you otherwise would have preferred to have. Now, with a living trust arrangement, included in the durable power of attorney for financial and legal affairs, we can add a power to allow your competent spouse to amend the trust in the name of both spouses. And this way, you maintain that flexibility. By the way, this is a power that we would only give to the spouses, not to anyone else, because it's only the spouses that we want to be able to change the trust. The next document in your living trust arrangement is your will. And you're probably thinking, well, wait a second. I have a living trust. Why do I need a will? You still need a will because there are two types of assets that, by definition, are impossible for you to transfer into your trust at this time. The first asset is a forgotten asset, and I'm going to go through an example of that with you. Let's say 40 years ago you bought stock in XYZ Corporation. The day after you bought that stock, the company went bankrupt. Being rather disappointed in that development, you put that certificate in a folder, put it in your attic, and forgot about it. 40 years later, after your death, your backup trustee is going through your papers and finds the certificate. They call up a stockbroker and they ask, what's it worth? The stockbroker does research and reports back that the company was bought out of bankruptcy a week later. The name was changed and records were poorly kept, so you were never notified of the new name of the company. During that 40-year period, the company went through a series of mergers, acquisitions, splits, dividends, and today that stock certificate is worth $100,000. Well, frankly, that doesn't happen very often, but we do know it happens, so we have to have something to cover that. Now, because you forgot about that asset was not transferred into your trust, and it will have to go through probate. Now, it can go through probate in either of two methods. It can go through probate with a will, or it can go through probate without a will. Probate without a will is called intestate probate. It is the worst form of probate. Intestate probate takes even longer. It costs even more. But the worst part about intestate probate is that asset will not be distributed according to your wishes, but instead will be distributed according to Ohio law. And that means that that asset could go to people that you wouldn't give the time of day to, let alone your money. Instead, we have a will which is called a pour-over will. It acts as a safety net. It catches those assets after they clear your probate. And after they clear your probate, it automatically transfers them into your trust. So therefore, all of the protections and all of the instructions of the trust apply to that asset as well. And by the way, just because that asset is going through probate does not drag all of your other assets into probate. Instead, they remain safely protected from probate by your trust. The other type of asset that you cannot transfer into your trust at this time is an asset that you don't yet have title to. And I'll give you an example of that as well. Let's say you're inheriting money from somebody else's estate and you die before that probate is completed. Remember, I told you probate takes between 1 and 3 years or longer, and it is not unusual for people to die while they're waiting to inherit money from somebody else's estate. It's a rather sad commentary on probate, I must say, but it does in fact happen. Well, that asset will have to clear the first probate, and then it will clear your probate. Once it clears your probate, it will automatically be transferred into your trust, and therefore all the protections and all the instructions of the trust will apply to that asset as well. Another thing you may need, as I mentioned before, is a guardian appointed for minor children. In the event that a guardianship needs to be set up to take care of those minor children, if you're single, or if you and your spouse die together, someone has to be in charge of taking care of that child. And it is only through a will that we can appoint a guardian. So as you can see, a will is still a very important document. Now, the next document that we include in your living trust arrangement is the living will. The living will is a document that allows you to ensure that if you're in a permanent, terminal, medically irreversible state of unconsciousness, you will not be kept alive by means of artificial life support. The condition that I've just described to you, you and I would call a brain-dead coma. And most people don't want to be kept alive indefinitely, hooked up to machines, that is artificial life support, when they're in a brain-dead coma. Also, Ohio has wisely chosen to include a provision in the living will to allow you to ensure that if you're in that permanent, terminal, medically irreversible state of unconsciousness, you will not be kept alive by means of a feeding tube, because we know that people can be kept alive indefinitely by a feeding tube alone. The living will is best captured by one of the sentences that appears in the living will, and I'm going to read that to you now to help illustrate the true meaning of the living will. Permit me to die naturally, and provide me with only that care necessary to make me comfortable and to relieve my pain, but not to postpone my death. Don't keep me alive if I'm irreversibly brain dead. Now, the next document in your living trust arrangement is the durable power of attorney for health care. This is the document that allows you to ensure if you're unconscious, but let's say it's not a permanent state of unconsciousness. Let's say, for example, you're in an automobile accident. You bump your head, you have a concussion. You're unconscious now. You're going to be okay, but you must have medical treatment. And because you're unconscious, you cannot give informed consent. Well, if you don't give informed consent, someone will have to. And it is the probate court, that's right, the probate court, who has the jurisdiction to appoint who will give informed consent for those medical procedures if you can't. Well, the probate court is a stranger. That judge is a stranger to you and your family. And the probate judge will never know your family situation as well as you do. Instead, with a durable power of attorney for health care, you can appoint who will be in charge of giving that informed consent for you. And that person will determine what doctors, what hospitals, what medical procedures to take care of you with if you can't give informed consent to make those decisions yourself. This way, you can always have someone you know, love, and trust making those decisions instead of someone appointed by a stranger to you and your family. The next document found in your living trust arrangement are the documents that allow you to transfer your assets into your trust. The first document is a deed to transfer your real estate from you to you in trust. I prepare your deed for you. It will be signed, witnessed, and notarized and ready to be recorded. Along with your deed, I prepare the exemption from conveyance fee. The conveyance fee is like a sales tax in Ohio. It's $4 per $1,000 of valuation. And because you're transferring from you to you in trust your real estate, You are exempt from paying that sales tax, that is, the conveyance fee. Along with the deed and the exemption from conveyance fee, I prepare instructions for you on how to record the deed yourself. It is literally as easy as returning a library book. Now, some attorneys who do concentrate on living trust arrangements will transfer your deeds for you. They'll take care of recording them. However, since this is as easy as returning a library book, would you rather pay them their typical fees of $1,000 or more to prepare your living trust arrangements, or would you rather do something as simple as returning a library book yourself, record the deed yourself, and therefore save those fees? What we have to concentrate on is common sense. You see, I prepare the documents for you to allow you to make your trust effective. You'll be doing a little footwork to make those transfers happen, but you'll be doing it with my assistance and with instructions from me to explain exactly how it is done. Now, the next document shows you an example of a financial asset letter that will transfer your financial assets from you to you in trust. That letter starts out typically as a form letter for you to fill out. Again, many attorneys will fill out these letters for you, but I believe that this information is private and confidential to you. Attorneys don't need to know this information in order to make these transfers effective. My philosophy is to keep everything that's private and confidential to you as private and confidential as possible. I don't need to know this information to make these transfers effective. Instead, you fill out these forms. And as you can see, they're very simple. There's just a few things to fill out. Also, an added benefit is by you filling out these forms, you're creating a paper trail of your competence and your intent. If someone else fills these out for you, it's not showing that you're incompetent, but they're depriving you of the ability to demonstrate your competence by doing this yourself. So you actually have a better result if you do this yourself with the very simple instructions that I provide. Along with these transfer letters, I give you very simple instructions on how to use these letters, as well as a filled-out example customized for you on how to use the first letter, that is to transfer your financial assets into the trust. So it's very simple, and it's basically common sense. Now, the next document in your living trust arrangement is to transfer your unregistered assets from you to you in trust, such things as jewelry, clothing, furniture. These are assets that you can't go to a bank or a recorder's office to make the transfer effective, but instead would transfer with a bill of sale. And the bill of sale transfers from you to you in trust all of these unregistered assets, so none of them will have to go through probate after you pass away. The last document found in your living trust will be the amendment to your trust. This starts out as a form. It's a form that's filled in except for one thing that's not filled in, and that is your changes. We don't know what your changes will be in the future. I provide you with this form for you to fill out along with very simple instructions on how to fill it out yourself. 1 page of very simple instructions and 2 pages of examples showing you how the amendment may look once it's filled out, and a list of things that you may want to change. When you fill out the amendment, you'll do 2 signed, notarized original copies. One you will keep with your copy of the trust, one you will send to me. When we sign these documents in their final form, we're going to do 2 original copies of all documents except for your wills. Ohio only allows us to have 1 original set of wills in existence at any time. You'll take the bound copy with the wills. I keep the other copy as a backup copy. If anything happens to your copy, if it's lost or destroyed, I still have a backup copy to give you. However, if the backup copy is then later lost or destroyed, well, we have to start over again because obviously we've run out of originals. When I receive my copy of the amendment, I will do a full legal review of it. If there's anything wrong, if it needs any changes or corrections, I'll give you a call or write you a letter letting you know how to make that correction. You'll prepare the correction and then send me the corrected original to put with your backup copy. The service of keeping a backup copy and full legal review of all of your amendments is at no additional charge. The one-time fixed fee for all the documents that we've discussed today for your living trust is a one-time fixed fee of $250. There are no additional fees involved. Finally included in your living trust arrangement are the instructions for your backup trustees, also known as your successor trustees. This is a 2-page list of instructions for your backup trustee to follow that illustrates to them what they will need to do after you become incapacitated or after your death. On the other hand, there is the Ohio Probate Code. Now, the Ohio Probate Code is roughly 700 pages in length. The print size is roughly the size of telephone book type, and it's almost as interesting to read as the telephone book. This is the instructions to the executor of a will. This tells your executor how to take your estate through probate, and this demonstrates for you why probate takes so long, costs so much, and is so complicated. The instructions for your backup trustee, on the other hand, illustrate to you why a living trust is so much faster, so much simpler, and so much less expensive. Many people also ask me, well, will my backup trustee need to contact an attorney after I pass away to take care of my living trust? And the answer is typically no. The living trust is not like probate. It's much simpler. It's much faster. It's much simpler. And the idea here is to allow you to avoid all the problems that are involved with probate, or for that matter, all the problems that are otherwise involved with a guardianship. So yes, I will be available to your backup trustee to answer their questions. Typically, those are only a few minutes on the phone because it's so simple. But I want to give you that reassurance that a living trust is not like probate. It does not require all the complicated filings or all the expensive procedures that probate otherwise would require. Often I am asked how a living trust protects the inheritance of minor children of divorced or separated parents. Let's go over some general principles. If a custodial parent dies, what will happen to his or her minor child's inheritance from that parent? First, the probate court will have to name a guardian to take over the care of that minor child. The non-custodial natural parent is typically named as the guardian unless a showing can be made that the non-custodial parent is unfit or unable to care for that minor child's needs. Under the situation of a simple will, it is not unusual for the surviving parent to take over the estate of the minor child as well as his or her physical custody. In most cases, that would be appropriate. However, in some cases, it may not. Often the reason that people divorce is because one of them is not financially responsible. Under these circumstances, if a financially irresponsible parent gains control over the inheritance of the minor child, the assets and money could be squandered instead of being used for the child's needs. After that, no other resources would be available to pay for the expenses of that child. Even though the probate court may stay involved by requiring the surviving parent to report the expenditures made by the surviving parent, such reporting is seldom adequately enforced. And when problems are discovered, it is usually too late to fix. Also, even where it does not work, reporting to the probate court involves added expense, which takes money away from the minor child's inheritance. With a living trust, even if the surviving parent gains custodial control, he or she can be prevented from gaining financial control over the minor child's inheritance. Instead, a trusted family member or friend can be named as the backup trustee to control the minor child's inheritance. Remember, the backup trustee acts as a financial parent and therefore has the power to use that minor child's inheritance to take care of that child's needs. If money is needed by the surviving parent, who is the court-appointed guardian, that parent can request the money from the backup trustee for that child's care. The backup trustee can give the amount requested or needed to the surviving parent to cover that need, or if giving money directly to the surviving parent is not appropriate, then the backup trustee can make those payments directly to pay the bills to cover that child's needs. This way, the child's financial needs are protected from being squandered. Often I have clients who are non-custodial parents with similar concerns. Their concern is to prevent a surviving custodial parent from gaining control over their estate after they die. Remember, with a simple will, it is not unusual for a surviving parent to gain control over a minor child's inheritance. Many non-custodial parents are concerned that such control will be abused, and the money would be used to pay for things that the custodial parent for their benefit instead of the minor child's needs. Again, this is prevented where a trusted family member or friend is used as the backup trustee. In both of the above cases, with a living trust, there is also a built-in system of checks and balances. That is better than probate court involvement. The backup trustee is required to provide the surviving parent or guardian of the minor child with the financial records of the child's inheritance at least once a year. This way, the child's guardian or surviving parent is aware of what is going on, even though that parent will have no direct control over the money. This is done privately without the cost or interference of the probate court. Finally, let's talk about the procedure for setting up your living trust arrangement. I'm holding in front of you an example of a living trust that I would set up for you as my client. It includes all of the documents that we talked about today, and they're included at that one-time fixed fee of $250. Typically, the procedure for setting up a living trust involves starting out with an initial consultation. Now, the initial consultation is at no charge or obligation. Typically, it takes between an hour and a half to make sure that we answer your questions properly. And it's done with total and strict confidentiality. About a week later, I'll have your draft prepared for you. Now, your draft will not be bound, it's not tabbed, and every page is stamped draft, but it is a complete copy of your trust as it will appear in its final form, subject, of course, to any corrections or changes that you may wish to make before it's signed in its final form. Any changes or corrections that are made afterwards will be done with simple amendments, as we discussed before. Along with the draft, some people have trouble understanding the language of the trust. So what I have done is created a summary and explanation of the trust that goes through every single paragraph of the trust, paragraph by paragraph. It summarizes and explains for you in simple, common layman's terms what each and every provision of the trust means. And I've had excellent success with my clients with it. They tell me that they have a very good understanding of what otherwise might have been complicated for them. About a week after your draft is prepared, and you've taken it home to read it, we'll sign the documents in their final form. And that will allow you to have your trust put into effect, and then you can proceed with transferring the assets according to the instructions and according to the things that we've talked about today, to transfer your assets from you to you in trust to make sure your trust is properly funded. I want to emphasize again to you that what we've talked about today, the living trust arrangement, is set up with a one-time fixed fee of $250 of all the documents found in your living trust arrangement, as well as making legal review of all of your changes to your trust, that is, amendments. I know we've covered a lot of information today, information that's very important to you and your family. So I urge you to give me a call at area code 216-349-4889 to talk about setting up a living trust and to talk about setting up a free, no obligation initial consultation to go over confidentially what we've gone over today and to answer your questions privately. Again, my name is David Bernstein. Please call me at 349-4889. Thank you.